Welcome. Hi, I'm Ida Reis, certified divorce lending professional, and this interview is part of the divorce literacy series from the Divorce Lending Association. And we are with today my friend Tracey Perrick, who is a family law attorney. Tracey, welcome.
Thank you. Hi.
Tracey, can you tell us a little bit about your practice and what sort of cases you generally are involved with and how your practice works? Is it mostly litigation? Is it mostly alternative dispute? How do you do your practice? What do you do with your practice?
I would say it's a healthy mix of litigation and alternative dispute resolution. So 50-50 even. A lot of settlement, negotiations, mediations, and then about 50% litigation. That being said, most cases that are in litigation do settle, just sort of where along the litigation continuum do they settle?
Okay.
All family law.
Okay, so I'm going to try to ask a couple questions to help our listeners, and that would be, when you say settlement, can you define what that means? Does that mean going to court or not going to court, trying to avoid court? Tell us about that.
Well, parties have, in essence, two ways of getting divorced. Either they reach an agreement with their significant other that resolves all of the issues arising out of the marriage, or a judge decides all or part of it. That's sort of the two ways to get divorced. And so sometimes people are able to avoid filing in court and can use mediation, settlement discussions between lawyers to reach that agreement and do an informal exchange of documents and reach an agreement, all without ever having to file a contested divorce. And then all they need to do is file for an uncontested divorce from the court, because the court still needs to give you that rubber stamp, that judgment of divorce. The difference is the court just giving you the judgment of divorce, or are they deciding contested issues between you? As part of the litigation process, there's a long way between the time of filing for a contested divorce and the court hearing the case. And so most cases settle along the way. The court offers mediation, settlement conferences where the parties appear off the record, usually with a retired judge or a family law magistrate, to try to figure out, to try to resolve their differences. And if they do somewhere along the way, and they're able to reach an agreement and put it on paper, then their case converts from a contested to an uncontested, and then all they need is the judge to give them the divorce.
Okay, so to clarify for those listeners, once again, find sometimes this is a very common question, is you start with the Maryland settlement agreement, correct? That's where you're trying to start in most cases, not always, but if it doesn't go to court, do you start there? Can you sort of talk about that a little bit?
Starting with an agreement, is that what you're asking?
A settlement agreement, yeah, where everything is outlined, all the terms.
To settle, ideally, what you do is start talking about the issue, right? So
Okay.
if you're doing it, perhaps you need to do an informal exchange of documents if you're trying to resolve a case outside of court. If you're in court, you're doing the discovery process. But perhaps one spouse or both don't have enough information about the other party's retirement or financial accounts. And so they need to know what exists to be able to assess what is a reasonable settlement. And so maybe you exchange documents, maybe you exchange letters setting forth different terms. Ultimately, the goal is to put everything on paper by way of a marital settlement agreement, a separation and property settlement agreement, separation agreement, doesn't matter what you title it. It's got to be in writing, and it needs to address all of the issues arising out of the separation and divorce. If there are kids, it needs to address physical and legal custody, child support. It needs to address alimony. It needs to address the division of the property. And so ultimately, the goal is to take all your settlement discussions, maybe your term sheets or your letters between your lawyers back and forth, and put everything down on paper and sign it. And that would be your marital settlement agreement, separation and property settlement agreement, or just simply a separation agreement.
Yes. Okay, great. And in a lot of cases where they don't go to court, so is it most of the time sort of just the next step is the formality to get the final stamp, as you said, with the court.
If there's a
Because nothing
separation,
changes.
oh,
Yeah,
I'm sorry. If there's a separation agreement signed, then yes, the court is just going to review it, make sure everything's addressed, and give the parties a divorce, sign off on a judgment of absolute divorce. That's what the uncontested case is.
okay.
That's what the ultimate result will be. If parties can't reach an agreement, or perhaps one party is unfortunately burying their head in the sand, right? I don't want a divorce. I don't want to deal with this. Or settlement negotiations have stalled. Maybe mediation wasn't successful. Then the only other way you get a divorce is by filing a contested case. But the hope is, even if you file a contested case where you're saying to the court, hey, court, I want a divorce, and unfortunately, my spouse, we haven't been able to reach an agreement on anything. And so I need the court to decide. So you file a complaint for divorce. The hope is ultimately somewhere along the way of the litigation, you'll still be able to reach an agreement. It's just a more expensive way to do it.
Yes, yes. And thanks for clarifying all that for those who are listening, because I find that that's a lot of confusion around that, like what a contested or an uncontested, and also where do you start? And once you have this settlement agreement, then what happens? And so if most of the time when you have an uncontested divorce, do you think that it just gets ratified by the court, or are there changes often made in the settlement for some reason before it gets
No.
Yeah.
A court isn't usually going to interject unless something isn't addressed.
Okay.
Or, if child support is one of those big ones, the court's going to want to see what the child support guidelines. Parties, and I have to tell clients this a lot, two parties can't just say, pay me whatever you want for child support, or don't pay me anything, it's fine, we'll square up later. The court stands in loco parentis as the parents for the children that are coming before them as part of these cases. And Maryland child support guidelines are statutory and mandatory. So the court wants to see, what do the guidelines say based on each party's gross income, cost of insurance for the children, cost of work-related childcare, if any, potentially might be thrown in there. The court wants to say wants to see the guidelines and wants to make sure that the children or child is getting supported in accordance with the guidelines. And if there's a deviation, if it's upward, the court doesn't care. Great, the kid gets more money, whatever. But if there's a downward deviation, why? The lawyers are going to have to explain it. And that's the only time I've seen a court sometimes say, okay, I've noticed that there's a slight downward deviation. Why? But the court doesn't want to get in the way of people who've reached an agreement. They've negotiated, they've had lawyers, or they've had time to review the agreement, they've had time to take it to lawyers. Unless there's something missing, and they'll take a careful look at the child support and the custody piece to make sure physical and legal custody are addressed and the child support is properly addressed. But I haven't ever had a case. Now, again, maybe that's because I'm a lawyer and I've done my due diligence, and I haven't ever had a court say, I'm not going to sign off on this divorce.
Okay.
But a reason to have lawyers, right? To don't try to do this pro se. You want to make sure you have an agreement that says what you want it to say, means what you want it to mean.
Okay. Yeah, that's a great clarification, because people say that all the time. They'll come in and say, well, we figured it out. Well, yeah, we'll figure it out later. Can you
I always give the analogy of like an appendectomy. To my clients, it's a pretty simple surgery, straightforward, and a general surgeon could probably do it almost with his or her eyes closed, right? But we wouldn't try to do it on ourselves. We wouldn't be like, it's straightforward, I'll do it. I can just do it. No, and I mean the same thing with a legal document, So you're going to spend the risk of trying a non-family law lawyer drafting a separation agreement. You have an incredible risk of it not including something, not saying what you think it's supposed to say, missing a key term, and then you're in litigation over the agreement that could have been drafted with a little bit more money at the front end, but a lot less than litigating over it later.
Yes. Now, based on all of that you just shared with us, which was terrific information, if you had to give advice to somebody starting down this path, what would you tell them at this point in your career? Because you've had a lot of experience.
Starting down the path of wanting a divorce.
Yeah.
Well, one, I mean, I know it's hard to coming to see and talk to a lawyer is a huge step. It takes a lot of people a lot of time to get there. And I try to honor that and know what a big deal it is just to be there and to be putting those words out in the universe. I want a divorce. I'd like to get a divorce. Things aren't working, right? And so I would say that, first of all, get off on my soapbox, you get what you pay for. Like most lawyers do charge a consult fee, but that's, and I know that limits people from exploring different lawyers, but try to the best of your ability, find someone who's a good match. These are very personal issues that you want to feel comfortable with your lawyer talking about. And I will never take offense to someone who doesn't decide to hire me because it maybe just isn't a good fit, right? It needs to be a good fit, and that's okay. It needs to be a good fit for what you're going through. Also, just approach it generally, in my opinion, unless you've got an emergent situation, that's different, where you're getting your information gathering, because that's what your lawyer should be giving you your options so you can make an informed decision. I think gone are the days, or more and more, those lawyers don't exist anymore, when it was just, well, we're going to go to court, we're going to file, right? Lawyers make the most money going to court, hands down. But that's not best for families. And I always tell my clients, please don't pay me $20,000 to fight over 10. I'm not going to go to someone who's going to go over all your options so you can make a fully informed decision and make sure you're comfortable with that person and the personality mix, and ask questions, understand how the retainer works. Lawyers are expensive. They should go over the retainer, how the retainer works, how replenishment works. What does that look like? What are the different ways that you can get from where you are now to being divorced? It's not just court.
Yes.
And then I always tell my clients this, there are two people we cannot control that are probably going to really affect how this goes. And that's the other side and whomever they choose as their lawyer. So be prepared.
Yes. Exactly. Well, I want to ask if you have any final thoughts for us today. Anything we missed that you would like to share?
I don't think so. That's it. That was easy, Ida. Okay.
Yeah.
No, I don't think so. I think that I'm well aware that lawyers are expensive, and this is it is a huge first step for someone to go talk to a family law lawyer. And sometimes for some people, it's the first time they're putting in the universe that they want a divorce, or that maybe their marriage isn't working out. And I think lawyers, family law lawyers should be attuned to that and approach it with let me give you your options, and not be pushy either. Again, it has to be a good fit. These are really personal issues that we're dealing with. So.
Yeah. Agreed. Yeah. They have to feel comfortable with all the professionals they're working with. I thank you so much for sharing your valuable time today with us. And I wanted to have you tell us what the best way is to contact you.
The best way to contact me is through my email. Directly is fine. Tracey, Tracey, at A as in Apple, P as in Paul, MD Law. That's all one word, apmdlaw.com. Our website has all the contact information as well, www.apmdlaw.com.
Perfect. Well, thank you so much. Yeah, thank you so much.
You.
And again, thank you for sharing your valuable time today. We certainly do appreciate it. Thanks so much.